Morning, everyone. I'm Guy Harper, a partner here in our corporate and commercial disputes team. As Richard mentioned, we're going to be giving a talk concerning the practicalities of terminating contracts. I'm going to begin by recapping some of the main principles underpinning the right to terminate, and Ed will then deal with the potentially thorny issue of how to avoid losing your termination rights when dealing with a breach scenario, and finish by giving some further practical points to consider. So what is termination? Termination, as we all know, involves a decision by one party to exercise a right to bring a contract to an end prematurely. This might be because of a failure by the counterparty to perform, but may of course arise for tactical reasons, such as the contract no longer being profitable, or because of a general breakdown in relations between the parties. The effect of termination is that the party's future primary obligations under the contract fall away, and for those obligations to potentially convert into secondary obligations to pay damages. There are two relevant sources of termination rights: the common law and the express contractual provisions. Common law rights. At common law, a party can bring a contract to an end prematurely by accepting a repudiation by their counterparty. A repudiation involves a breach of a contract which is sufficiently serious to justify termination, or saying or doing something to indicate that the party doesn't intend to perform in a material respect, and that's known as a renunciation or an anticipatory breach. A common law right does not need to be preserved in a contract for it to exist, but can be excluded by very clear language in the contract. The second source, contractual termination rights. Whether there are any contractual termination rights, and if so, their precise nature and scope, depends on the terms of the contract. It may be, although this is relatively rare in commercial contracts of any significant length, that there are no contractual termination rights. A party, this is a frequent question, a party is not generally under a duty to act reasonably, rationally, or in good faith when deciding whether or not to terminate. That said, and notwithstanding that the right to terminate is a highly fact-sensitive issue, one broad theme is a judicial bias against cynical termination. The courts generally don't want to allow trivial or inconsequential breaches to lead to early termination, and err on the side of certainty and contracts being performed. Absent very clear rights to terminate for convenience or a binary breach situation, a party should have an eye on showing that it has acted reasonably, notwithstanding that it usually doesn't have a contractual duty to do so, in order to carry the court with it. That may, if necessary, include giving their counterparty the opportunity to cure their breach. One final point before we move off this introductory section, is that if it is worth checking when considering your breach rights to assess whether or not any fraudulent or negligent pre-contractual misrepresentations can be identified. If they can, the misrepresentation would give an arguable basis to rescind the contract. The effect of the rescission would be to void the contract and restore the parties to the positions they would have been in had the misrepresentation not been made, which in many cases would involve returning them to their pre-contract positions. This is particularly attractive for a claimant who has made a bad deal by entering into the transaction, because the tort measure of damages is likely to result in a higher level of recovery, because contractual damages look to put the party into the position they would have been in had the contract, in this case a bad one, been properly performed. If you remember one thing from my part of the talk today, it should be to take care not to fall into the trap of just considering express contractual termination rights in a breach situation. Contractual termination provisions can risk being a false friend. There is a fundamental difference between the calculation of damages in a contractual breach situation as against a common law acceptance of repudiatory breach. Both involve payment of against losses caused by the breach up to the point of termination. However, when a party terminates for a repudiatory breach at common law, there is a clear entitlement to loss of bargain damages, subject to any exclusions or limitations of liability under the contract. Loss of bargain damages aim to put the innocent party into the position that it would have been in had the contract been performed in future, This therefore allows a claim to future lost profits. Now, the effect of getting this wrong can be extreme, as this case shows. This relates to a dispute between EE and Phones for You, an entity now no more. In 2014, Phones for You's business was failing, and following the lead of several other networks, EE informed Phones for You that it didn't intend to renew its contract with them, which in turn led to the board of Phones for You to enter into an insolvency process, in this case, administration. The contract between EE and Phones for You contained a standard termination clause, which allowed EE to terminate solely on the grounds that Phones for You had entered into administration. Sure. The relevant part of EE's termination notice is on the slide. And as you will see, it refers just to the fact that EE was purporting to exercise its contractual termination right only, whilst containing a general reservation of rights under the agreement. Now, EE pursued a claim for over 200 million of loss of bargain damages flowing from Phones for You's breach, and Phones for You applied for reverse summary judgment to dismiss that claim. Now, whilst the court held that there was a realistic prospect that EE would establish at trial that Phones for You's breach was repudiatory, in that at the date of termination, the cessation of trading was likely to result in EE being deprived of all or substantially all of the benefits of the contract, the terms of the termination letter defeated EE's claim to loss of bargain damages. This was because the termination letter failed to state that EE was exercising its common law right to terminate by accepting the repudiatory breach. Whilst the letter contained a reservation of rights, the judge held that a merely reserved right is not a right exercised. Now, the simple fix here would have been for EE to say in its termination notice that it was accepting Phones for You's repudiation and terminating pursuant to its contractual right, effectively riding both horses. Turning to the question of whether a particular breach will give rise to the right to terminate depends on the type of term that has been breached. Bit of back to law school know-how here. The three categories of contractual term at common law are as follows. A condition. Now, breach of a condition will allow for instant termination, but conditions are increasingly rare. Labeling a contract, a term as a condition is instructive, but not necessarily determinative. For example, auction houses trade under conditions of sale. This shorthand doesn't make every obligation in the contract a condition. Parties are obviously careful in practice to avoid classifying obligations as conditions, and key exceptions are clauses which provide for time of the essence, although these are also increasingly rare, and conditions as to ownership and title under statute. The second category, intermediate terms. Here, a breach will entitle the innocent party to terminate only if it is sufficiently serious, i.e. it goes to the root of the contract. In practice, most contractual terms now are intermediate terms. To identify a breach of an intermediate term, you need to engage in a fact-sensitive inquiry and identify the benefit of the contract. You need to consider how much has already been received. What loss has the breach caused so far? Has the breach been repeated or remedied? And what reason is there to expect that to change or continue? In many cases, there is no clear answer to these questions, and two observers may reach two very different conclusions. If there is genuine room for doubt, exercise restraint, as a wrongful termination would itself be a repudiatory breach of contract, and as we saw earlier, expose you to a claim for loss of bargain damages. The final category of term is a warranty, which don't allow for termination no matter how serious the breach. Other than provisions of contracts which are expressly labeled as warranties, this category is also increasingly now rare. The second category of rights to exercise common law termination rights is where a party has clearly demonstrated intention not to perform the contract. Here, the innocent party doesn't need to wait until time for performance to see whether their counterparty will in fact be in breach. The right to terminate arises immediately. Now, this is renunciation or anticipatory breach. A renunciation can be by words or conduct. the party may expressly declare that it no longer intends to perform, or the party's conduct may be such as to lead a reasonable person to conclude that it's unwilling or unable to perform. Now, not just any old threatened breach will amount to renunciation. Where a party intends to perform some but not all of its contractual obligations, the question is whether the anticipated non-performance will amount to a breach of a condition or a sufficiently serious breach of an innominate term. The question of whether you have your contractual termination rights are engaged will obviously turn on the construction of the relevant provisions, and the normal principles of interpretation apply. Looking at some of the key clauses that you see in commercial contracts at the moment, substantial breach is an expression that the courts have held means a breach equivalent to a repudiatory breach at common law. Paradoxically, that is the same for any breach. Whilst it's on its face a very broad expression, the courts have interpreted restrictively because the courts consider that it would flout business common sense for the parties to be able to terminate for trivial or inconsequential breaches. Material breach, which I think is the expression you see most often, the courts have held that this is a lower hurdle than the one required to exercise common law rights. It connotes a breach of contract which is more than trivial but need not be repudiatory. One final point from me before I hand over to Ed. Relatively recent changes to the insolvency legislation introduced during the pandemic with the aim of shielding businesses from the economic impact of lockdown included the Corporate Insolvency and Governance Act, CIGA. Some of the protections implemented were temporary, for example, restrictions on winding up petitions, but some of it is here to stay. One of the permanent measures was a restriction preventing suppliers of goods and services to insolvent companies from terminating contracts by reasons of insolvency alone. This measure was introduced to provide the opportunity for the insolvent company to trade out with a view to rehabilitation. So where you are looking to exercise what is relatively standard, a contractual termination right for the party, your opposing party's insolvency, a corporate customer's contracts for the supply of goods to it, of goods and services, are protected from termination once it enters the insolvency process. At this point, existing contractual termination rights for insolvency cannot be exercised. Whilst it's a grey area and hasn't been tested, the general consensus is that a supplier is not prevented from exercising their common law termination rights in this scenario. Thus, if a customer enters insolvency and otherwise acts in a repudiatory way by committing a serious breach going to the root of the contract, the supplier should still be able to rescind. Now I'm going to turn over to my colleague, Ed Davis.
Thanks, Guy. So Guy has been talking about the circumstances in which you can terminate a contract for breach, and I'm just going to move on to discuss what you need to do and think about if you actually want to terminate when there is a breach. You're probably aware that if your counterpart breaches a contract, the contract doesn't automatically come to an end. Basically, what you have to do is come to a decision, as to whether or not you want to terminate the contract, or to, as Guy said, by accepting the breach, or to affirm the contract and carry on with it. And you do that by making an election. And an election is an outward statement or conduct which unequivocally indicates to the other party that you've made a decision, an election, whether to terminate the contract or to continue with it. And if you decide that you want to affirm the contract and your words or actions basically indicate that you're going to continue with the contract, then you lose your right to terminate the contract for good for that breach anyway. But as it says on the slide, you won't lose your right to damages. So we're just talking about termination here, not damages. Now, the reason this is important, and like Guy was saying, if there's one thing you want to take away from this, I think it's at this point, which is that you can quite easily and inadvertently lose your right to terminate by affirming a contract when you don't mean to. So you basically have to be very careful. And there's two ways in which you can lose the right to terminate a contract before that right is used, either by a reasonable time passing without you doing anything, or if you do something which is inconsistent with termination, such as receive or demand a payment or make a payment, generally do a substantive performance under the contract. You can try and preserve your rights and extend the time by which you have to terminate, and I'll come back to that in a minute, but those sorts of reservations of rights only go so far. You don't have to decide immediately if you want to terminate or affirm the contract, because you do have a reasonable period of time to decide what to do. That then, I guess, begs the question, what's a reasonable period of time to make a decision whether to terminate or to affirm the contract? And the helpful answer is that it depends on the circumstances, and it varies from one case to another. So just to give you an idea, there are lots and lots of cases on this. But if, I guess broadly, if it's a short-term contract, say you've got a volatile market, it's a pretty simple, straightforward scenario, then in those sorts of circumstances, a short period is likely to apply. So in one case, it was said that less than 13 days was enough time to decide whether or not to terminate a contract to sell a racing car. You could have a situation, on the other hand, where the facts are pretty complicated, there's no real urgency, and it just takes a bit of time to work out what you want to do, to investigate the facts and so on. And so in another case, although 2 to 3 months had passed, that was said not to be enough to affirm the contract. But I think the takeaway is that if you don't act relatively quickly when your counterpart terminates, breaches a contract, to accept the repudiation, you can lose your rights to terminate. That's the, broadly speaking, and very quickly, the common law position. When you have an express contractual right to terminate, it comes down to a question of construction of the relevant clauses, but essentially the position is the same, which is, again, if you have a right to terminate a contract under an express clause, you almost certainly will still have to make a decision as to whether to terminate or not relatively quickly, and be careful about doing anything that would be said to affirm the contract and lose that right. I mean, as I say, it depends on the contract. There could be terms which, for example, will give you a period of time in which to make a decision. But even there, you still need to be careful about continued performance of the contract and waiving your right to terminate by doing that. One thing we quite often see is parties trying to rely on no waiver clauses to argue that they can take longer or as much time as they like to decide whether to terminate a contract or not. Again, it comes back to the construction of the clause itself, but rarely do no waiver clauses help. because we're not talking about waiver, normal delay. This is a decision, basically whether or not to terminate or not. And so the courts have said that those sorts of clauses don't really help. If you wanted a clause to work like that, it would have to go a lot further, I think, and say that if there's a breach, then the innocent party can, take a certain period of time, or as long as it wants, or something like that. They're pretty rare as far as I'm aware. And even if you have a clause which allows you a lot of time to decide whether to terminate, that wouldn't help you if you did something that was inconsistent with the right to terminate, like start making payments under the contract. And of course, the longer a contract goes on, the harder it is to avoid doing things that could be said to affirm the contract. I mentioned earlier as well, sending reservation of rights letters. It is a sensible thing to do if you've got a contract, your counterparty is in breach, and you need to decide what you want to do, whether you do want to terminate or not, and then to send a letter saying that you're aware of the breach and you're considering your options. But that only goes so far, and there's a case on the slides there, Lombard North, where the court made it clear that what it called the ritual incantation of words reserving rights basically isn't going to save you if you don't get on and make a decision. So I'll just wrap up by trying to bring together what we've talked about just now, and perhaps highlight some of the practical consequences, practical things to think about when you want to, or you're considering terminating a contract. Obviously the first thing you would need to decide is whether you want to terminate the contract at all, or are you better off keeping it? Maybe the relationship with the other side is sufficiently important or strong that you don't want to terminate, and you might want to instead just claim damages or not even do that. But the other thing which is related is to think about the practical consequences of termination. So, do you have a load of goods in a warehouse that you need to deal with? And one thing that we come across a lot is the situation where you want to terminate, but you need someone to take over the contract if it's a long-term, say, services contract. And the issue that we encounter there is it does take a lot of time to find someone else to take over. And if it's an important contract, you can't just terminate it and then have no contract in place. You'll need to do your due diligence on a replacement and that sort of thing. But of course, whilst you're doing that, the existing contract is still alive, and then you risk being said to have delayed terminating or to have taken steps to affirm the contract in the meantime. So there's no perfect solution to this, but I guess the key thing is to act very quickly if you want to terminate and find a replacement. An obvious point as well is be sure that you have good grounds to terminate. I won't go back over what Guy was saying about things like material breach, but you need to be pretty sure that you do have good grounds, either common law or under the contract itself. Because, as Guy was saying, if you give an indication by sending a termination notice that you're not going to perform yourself, then that will mean that you yourself are in breach of contract if there weren't good grounds to terminate. You often see clauses that say that a party can only terminate if a breach is uncurable or has not been cured after a certain period of time or has not been cured after notice. So you need to look out for those sorts of provisions. I think I've banged on enough about waiving rights and affirmation, but obviously don't take too long if you're terminating. You don't take steps to perform, and you have to sort of come to a decision pretty quickly as to whether or not you want to terminate. And it's always worth sending a reservation of rights letter in the meantime, but bearing in mind they're not, not a complete answer. We often see people going wrong with termination notices just in terms of the contents of them, or not complying with notice provisions. So you do need to check the notice provisions and any other requirements in a contract, and comply strictly with those. As Guy was saying, it's very important to think about whether you've got overlapping common law and contractual termination rights, and rely on both if you can, so you don't end up restricting your ability to claim damages. Some contracts require you to identify the breach. You don't have to identify the breach at common law, but often contracts will say that if you're terminating, you have to set out in reasonable detail the ground on which you rely. There's a whole other topic, but think about regulatory issues and other issues that don't just relate to the contract itself. For example, in the financial services context, things like treating customers fairly and so on. When it is a slightly odd thing that when contracts are terminated, the contract doesn't end completely. So some provisions will continue and survive termination, and often in contracts they'll expressly say which provisions are deemed to continue, things like confidentiality obviously, but there might be obligations to destroy documents. So it's always worth checking what your obligations are post termination before you terminate and it's too late. And then finally, just think about privilege and communications, because whilst you might be in a dispute with your counterparty in the sense that you think they've breached a contract, it's normally unlikely at this stage that litigation will be in contemplation, so that communications will be privileged. So obviously when there is a termination, litigation often follows, and so all communications could end up in court. So you just either channel things through lawyers or be careful about what is put in writing. Privilege is a whole other topic, which fortunately is the next on the agenda, so I'm not going to say anything more about that. So that's all. That was a very quick canter through termination.